focus on environmental prosecutions. I'm going to talk to you today about a number of different types of privilege that exist in environmental enforcement, and specifically with respect to prosecutions. But you'll note that a lot of the different types of privilege that I speak about today actually also exist in the world of civil and administrative hearings with respect to the environment. The focus is going to be prosecutions because that's what I know. Figure out how to move this thing. There we go. There's a disclaimer only because my paralegal told me I had to have one. So the opinions here are my own and not that of the Public Prosecution Service of Canada or the Attorney General. Before I move on to the next slide, I actually want you guys to use your imagination. I don't know if any of you were a fan of Choose Your Own Adventure novels as a kid. They were written in the 70s, 80s, and 90s. And basically, you got to read partway through and then choose which route to take next. So I want you guys to use your imaginations. Imagine that you are defense counsel for an oil company. For some of you, that doesn't require too much imagination. But imagine that that's what you are. You're a defense counsel for an oil company, and they're being investigated for an oil spill. And they're being investigated under the Fisheries Act and under your Provincial Environmental Protection Act. And nicely, the investigators have given you a bit of a tip. They said, look, we are going to execute a search warrant, and we're going to do it in the next week. So just so that you're a little bit of aware, we're going to come. And you know that there's probably some solicitor-client privilege documents that they're going to find when they're executing their warrant. So this is where you get to choose your own adventure. So, Route A. When they show up, the investigators, to execute their search warrant, you claim privilege over all the documents related to the oil spill incident. Okay. Route B. There's a bunch of previously existing documents, and you have the vice president of the oil company send you all these documents by email the day before they come to execute the search warrant. Okay. Route C. You claim solicitor-client privilege over the internal investigation report that the oil company did after their oil spill incident. And Route D, you claim solicitor-client privilege over documents which are legal advice between a lawyer and the company. Or Route E, some combination of the above. So choose your own adventure. Keep this in your mind, and I'm not going to talk about it in detail now. We're going to come back to it later in my presentation and see if the route that you chose has changed. Now, I thought if I'm talking about privilege, I better give everyone a Privilege 101. I mean, we all kind of know the basics of privilege, but what's its purpose? And in order to understand its purpose, we have to go back to two important rules. So there's one rule with respect to prosecution and one rule with respect to civil litigation, and they're very similar. In prosecutions, we have to, as the Crown, disclose all relevant information to the accused so that the accused can make full answer and defense. And that's the Supreme Court of Canada case of R versus Stinchcombe. In civil litigation, there's a similar rule that all relevant evidence should be available to all parties in the litigation. So we have to keep those rules in mind when you think about where privilege came from. Now, privilege is an exception to these rules, and it's an exception because it precludes obtaining and tendering evidence. And this privilege has been developed over time through the common law, sometimes through statutes, for certain reasons. And the key reason is to prohibit disclosure of evidence that could cause serious harm if it were disclosed. And that serious harm could be to people, it could be to the judicial process, and it could also be to the general public's interest. So that's why privilege exists. These are the types of privilege that are found in environmental enforcement. And I was actually really surprised. When I was first handed this topic, I thought, what on earth am I going to talk about for 45 minutes? But when I started to think about it in detail, there's a lot of different types of privilege that's encountered in environmental enforcement, and more than I'd actually realized. And most of these I've encountered throughout my practice. I'm going to go through them, some of them quickly because we don't have a lot of time. And the way they're listed there is more or less the way that they would be encountered in that order. in an environmental investigation and a prosecution. So the informer privilege is the one that you would most often encounter if you were an officer doing an environmental investigation. That would be the first privilege that you would encounter. And you'll see that 2 of these have an asterisk: informer privilege and solicitor-client privilege. These are types of class privilege. I'm going to speak on that in a little bit more detail. Class privilege, there's a prima facie presumption of inadmissibility of that particular information. And that's contrary to case-by-case privilege. Most privilege falls under case-by-case privilege. And it's a prima facie presumption of admissibility of the information. And in order to become inadmissible, the information has to meet the Wigmore test, which some of you might remember from law school, or sometimes there's a slight variation of the Wigmore test depending on the type of privilege that you're trying to assert. And in general, these tests are trying to balance the general interests of the public with keeping that information secret with the interests of the accused in having that information given to them for full answer and defense, or in a civil case, the interests of the parties in having that information disclosed to them. So it's up to a court, if there's a challenge with respect to privilege, to weigh those interests, the interests of the general accused with the interests of the parties in having the information disclosed to them. I should note that case-by-case privilege has a subcategory called public interest privilege. And a lot of the types of privilege I'm going to speak about today fall under that subcategory of public interest privilege. And an example will be investigative technique. And that's protected by common law. Public interest privilege, you'll see lots of cases on common law dealing with it, but you'll also see it under Section 737 of the Canada Evidence Act. So that section of the Canada Evidence Act protects public interest privilege. So we're going to jump right into the various forms of privilege I'm going to talk about today. And the first one is informer privilege. So informer privilege arrives when a person has provided information to investigators and they want their identity to remain confidential or anonymous. Okay? And the purpose of informer privilege is twofold. The first is that it protects people who've provided information to officers. But the second purpose is that it encourages people in the general public to come forward with information that might be relevant to an offense. Now, informer privilege is granted only by the Crown, and not everyone who wishes, every witness who comes forward who wishes to be anonymous is going to be granted informer privilege. Okay? This is something that's granted by the Crown in specific circumstances where they feel it's important that the person's identity remain anonymous. It's often for safety reasons. And it's only the informer who can waive the privilege. The Crown can't waive it. Only the informer can waive it once it's been granted. In the prosecution world, we protect informer privilege by redacting all information that could identify the informant. So all information when we're providing disclosure to accused that could identify the informant is redacted out of the disclosure, to the point that in some cases, even indicating the existence of an informant could cause that informant's identity to be revealed. So as much as we can, we try to make sure that even the existence of the informant is not released. In the world of environmental prosecutions, we often will receive a tip from someone in the general public that lets the investigators know that there's been some sort of environmental offense. So someone reports that they've seen a spill or they've seen wildlife killed, and that's how the investigation commences, and this individual wishes to remain anonymous. And this can be especially important, this anonymity, in a rural area. If there's not a lot of people in a rural area who could have seen the incident occur, then there's more of a likelihood that whoever complained will be identified. So that might be an instance where informer privilege would be granted. Another one that we see, I've seen several times in environmental cases, is a tip by an employee of the company that has caused the incident that's under investigation. And in these instances, you often have an employee who's worried that they'll get fired if the company finds out that they were the one that gave the tip. So this is one of those instances where even identifying the existence of the informer could cause their identity to be revealed. Basically because if the company knew, they might start going on a witch hunt to find out who that individual was. Tips can be made in a number of ways. We all know about Crime Stoppers, but all provinces have their own environmental hotline that people can use to give tips. And Crime Stoppers and environmental hotlines are anonymous. They're a type of informer privilege. And there is a case from the Supreme Court of Canada called Liepert, and it says that even the tip sheet that the person on the other end of the phone who takes the information down when the tipster calls, even that tip sheet is informer privileged, because the information on that tip sheet could reveal the identity of the witness. Investigative technique. This privilege involves disclosure of a technique where if its disclosure occurred, it could undermine the use of that investigative technique for the current investigation or for a future investigation. And this is what often results in an information to obtain a search warrant being sealed. So search warrants, often you always need an information to obtain that gives you reasonable grounds for executing your search warrant. Sometimes those informations to obtain, or ITOs, are sealed because they would disclose important information, and in some cases they're sealed because they would disclose information regarding an investigative technique. And this investigative technique privilege is an example of case-by-case privilege. And in this case, you have the court balancing whether, the interests in keeping the technique secret with the accused's interest in full answer and defense. And in the environmental world, I definitely see investigative technique privilege. There are techniques that need to remain secret. There's lots of examples that I could give you, but I can't because they have to remain secret. But I can say that in wildlife trafficking, it's an area where there's some very interesting techniques. An example I can give you would be simply keeping the type of vehicle that's used for an undercover operation secret. Okay. That's a simple example. They get pretty elaborate. Ongoing investigation privilege. So information about an ongoing investigation is privileged where its disclosure would undermine the investigation. So for instance, if you gave information out about an ongoing investigation, it could cause people related to the investigation to go out and destroy relevant evidence, as an example. And the Crown, again, this is case-by-case privilege, and so the court has to balance the interest in disseminating information of an ongoing investigation to the public with the importance of keeping that investigative information secret. And there's lots of reasons for keeping investigative information on an ongoing investigation secret. We talked about destruction of evidence, but there's also having lack of cooperation with witnesses if information's been revealed. You need to protect the rights of the entity or individual that's being investigated. And we all know that there's a right to being presumed innocent before guilty. You have to protect the rights of third party and their third party privacy interests, so witnesses who've given information, their privacy interests need to be protected in an ongoing investigation. If you start giving out more information than you should about an investigation, you end up contaminating the minds of witnesses and potentially contaminating any potential jurors. And there have been instances where police have given out too much information about an investigation while it was ongoing, and it's required courts to have the trial move from the jurisdiction where the offense happened to another jurisdiction because there was just too much information out there. Another issue with releasing too much information during an ongoing investigation is that police agencies can end up with civil actions against them for release of the information. Particularly if charges don't proceed after the investigation, you have whoever was investigated. There's been a lot of information out there in the public. There's adverse publicity, there's loss of business, there's loss of reputation. So there's lots of reasons for keeping investigative information secret. One case I've mentioned there is R versus Trang. It's an Alberta Queen's Bench case from 2002. It goes into a little bit more detail about investigative privilege and ongoing investigation privilege. In this case, I've seen it used not just in Alberta, sort of more of a general application case across the country. Next is third-party privacy, and I say privacy on purpose. This is not privilege, but I think it's really important to recognize it's important, third-party privacy is important to protect in all prosecutions, including environmental prosecutions. And the Crown protects third-party privacy by redacting personal information about the third party when disclosure is made to an accused. So generally when I'm talking about third parties, I'm talking about witnesses. So when we provide disclosure to the accused, we leave the witness's name in and we leave in all the information that they've given that was important, but we take out things like their home address, their cell phone numbers, their home phone numbers, their date of birth, their SIN number, their driver's license information. All that core private information about an individual is redacted out to protect their third-party privacy. There is information about third-party records that would be important for the work that many of you are doing, protecting the privacy and confidentiality of third-party records. I don't have time to get into that in detail because it's not privilege. It's a type of confidentiality and privacy, but there's 3 cases I've listed from the Supreme Court of Canada that will give you more information on third-party records: O'Connor, Mills, and McNeil. National interest privilege. This privilege exists where disclosure of information would have some sort of negative impact on national interests like national security, international relations, national defense. And it's actually protected under Section 38 of the Canada Evidence Act. And Section 38 applies to criminal and civil trials as well as federal tribunals. I've given a case, Abu El Mahdi. It's an Ontario Court of Appeal case from 2011. And Abu El Mahdi sets out the test under Section 38 of the Canada Evidence Act for determining whether or not there is national interest privilege attached to some sort of documentation. And again, it's case-by-case privilege, so it requires the courts balancing the interests of the public in having the information disclosed with the interests of the public in having the information not disclosed. It's very case-by-case depending on what the documentation is. I should actually, before we move on to cabinet confidences, talk a little bit about national interest privilege in the context of environmental prosecutions. I've dealt with cases involving radioactive materials where the materials could harm the environment or have human health impacts. And while I've actually never seen national interest privilege in an environmental case, because of those radioactive material cases I've dealt with, I can see where national interest privilege could arrive with respect to having national security or national defense issues. So cabinet confidences. Documents of the Privy Council are privileged, and the Privy Council includes the Prime Minister's cabinet. So all documents that come out of the Privy Council can have privilege claimed on them. They include things like memorandum with proposals and recommendations, discussion papers that have background information, analysis or policy options, briefing notes for ministers, draft legislation. These are all things that have cabinet confidence or privilege attached to them. Section 39 of the Canada Evidence Act protects cabinet confidences, and it actually indicates that it's a sort of an automatic privilege. So as long as there is a certificate by a minister or a Privy Council clerk saying that this particular document is a cabinet confidence, that privilege is automatic. The court does not even review whether or not privilege connects to those documents. In the environmental context, I have seen in environmental prosecutions cabinet confidence documents. I've seen them in one instance that I can recall for certain, and I think they would arise in civil and administrative environmental hearings as well. The instance I had it arise was when I wanted to know more information about why legislation was drafted the way it was. I was dealing with an environmental sentencing hearing the individuals had failed to file a report, and I wanted to know what was the environmental harm behind failing to provide the report. Why did failing to report this, file your report, why was this made an offense? So I asked for some information to assist me on sentencing and understanding that better, and the information I got back, I did have a cabinet confidence document that was included, and once I recognized that, it's not something I would disclose to accused. So solicitor-client privilege. I really hope we all know this, but as a review, solicitor-client privilege is communication between a solicitor or lawyer and a client for the purpose of seeking or giving legal advice, and it's legal advice that is intended to be kept confidential. So not all communications between a lawyer and a client are privileged. It's communications that are for the purpose of confidential legal advice. Its solicitor-client privilege can be waived by the client, not by the lawyer. It can also be waived if it's disclosed to a third party, even if it's disclosed unintentionally. The key case is an older case from the Supreme Court of Canada, Solowski versus the Queen from 1980. And solicitor-client privilege, I think, is the area of privilege that we encounter most in environmental prosecutions. We encounter it, first of all, because all communications between Crown Counsel and the investigative agency are solicitor-client privileged. And by Crown Counsel, I mean Public Prosecution Service of Canada, Provincial Justice Council, and also departmental legal solicitor units. So on the federal side, every agency has its own in-house solicitors. So for example, Environment Canada has their own in-house solicitors to advise them, generally on non-prosecution matters, and they're called DLSU, or Departmental Legal Solicitor Units. So that's another area of solicitor-client privilege dealing with the investigative agency. During an investigation, solicitor-client privilege documents are often encountered by investigating officers. They can be solicitor-client privilege documents between the potential accused and their counsel, or between third parties to the investigation and the third party's counsel. I want to talk a little bit about what happens in the execution of a search warrant when there's a claim of solicitor-client privilege. The first time that I had to deal with this issue, I had no idea what the practical application was. In practice, how does this happen? So I've made a couple of notes here, 5 points, and I'll go through to try and explain to you the process. There's no statutory process when a search warrant is being executed, and whoever is being executed against wants to claim solicitor-client privilege over documents. There's definitely case law that provides some guidance, but practically speaking, this is what I've learned that happens. So the first thing that happens is during the execution of the search warrant, if an investigating officer comes across a document that they think looks like it's solicitor-client privilege, the investigating officer will put that document into an envelope, seal the envelope, label it, number it, according to their own protocols. Alternatively, during the investigation, there might be employees or counsel present during the execution of the search warrant and they recognize that there's some documents that privilege needs to be claimed over. And they raise those and say, hey officer, those documents there, I think those ones are solicitor-client privileged. The officer takes those documents, puts them in an envelope, seals the envelope, labels it. After the execution of the search warrant, the officer takes those sealed envelopes to Queen's Bench or Superior Court, depending on your jurisdiction. And then after they've been housed in Queen's Bench, counsel from whomever the search warrant was executed against can go to Queen's Bench and go through those documents to determine which ones really are solicitor-client privileged and which ones aren't. You actually sit, for the most part, in QB in a little room and you go through the documents. And in my practice, defense counsel generally put the documents into 3 categories. Category 1, these are documents that are truly solicitor-client privileged. Put them in one pile. The next pile is documents that we've reviewed and there's no solicitor-client privilege on these documents and they're released to the investigating officer. Pile number 3 are documents that may possibly have solicitor-client privilege attached to them. So piles number 1 and piles number 3 stay put back in their sealed envelopes and stay in Queen's Bench. Then it's up to defense counsel to bring an application before the court to review the remaining documents to determine whether or not they're solicitor-client privileged. And the court will go through the documents one by one to see whether or not privilege exists. And the party claiming the solicitor-client privilege has the onus of proof on a balance of probabilities. And not surprisingly, I have come across instances where defense counsel has dragged their heels in bringing such an application in the middle of an investigation, and I've had to knock on their door and say, please bring this, and still they don't bring it. So the Crown has ended up having to bring the application to have the court review the documents. But in the normal course of it, it is the person who's being investigated that's trying to assert the privilege. They should be the ones that are bringing the application. I want to talk a little bit about electronic documents. So I've given you the process for what you do to claim solicitor-client privilege over actual physical documents during the execution of a search warrant. But what about when it's electronic documents? What about when the entire computer is seized, or its hard drive, or when the investigating officers sees a mirror image of the hard drive? So instead of actually seizing the hard drive and taking away with them, they make a mirror image, which is a copy of everything on the hard drive. There's several different options to deal with a solicitor-client privilege claim over documents that are on the computer or the mirror image. And there's no right or wrong answer to any of the routes that I'm going to tell you. And in my experience, whatever route is chosen is usually done in consultation between Crown Counsel and Defense Counsel for the entity being investigated. So route number 1 is that you can actually seal the computer or the mirror image and have it taken to QB. I can tell you that Queen's Bench does not like to receive entire computers and hard drives. They don't have a lot of space to store stuff. And then later on, counsel can come in and review the information that's been sealed, or an investigating officer can do so. But the alternative is not to seal that computer or that mirror image right away. The alternative is to have the investigating officer do a search of the image or the computer using search terms that are relevant to the 4 corners of the warrant. And sometimes those search terms are created by the investigating agency. Sometimes those search terms are created between Crown and Defense Counsel in consultation. Another option, instead of having the investigating officer search using search terms, is Crown and Defense Counsel agree to have someone independent from the investigating agency. So in the environmental world, it's often an RCMP officer or a retired RCMP officer who comes in and does a search of the computer or the mirror image using search terms relevant to the search warrant to find the documents that are relevant to the actual search. And when they come across solicitor-client privilege documents, they have an option. And again, this is often agreed upon beforehand between Crown and Defense Counsel. The officer that's doing the search, using the search terms, if they come across solicitor-client privilege documents, they just ignore them. They leave them there. They make either a printout or an electronic copy of the documents that are relevant, and often the computer will be returned to the owner. Or, while they're doing their review, if they come across solicitor-client privilege documents, they actually print them out or put them on a thumb drive, seal them, and take them to Queen's Bench, and then that review process by counsel starts just on those particular ones, and the other documents that were relevant go to the investigation. So that's generally the process. I was going to add more, but I'm not. It gets even more complicated depending on what's seized. But I'd like to come back to the Choose Your Own Adventure story that we started with, and go through each of the different routes that you could have chosen. So first of all, did you choose privilege over all the documents related to the oil spill incident? Not a good idea. Defense counsel in environmental cases have actually tried this a few times I've been involved in, And it's like throwing a magic cloak of privilege over all the documents related to the incident. But there's no such thing as a magic cloak, okay? The magic cloak doesn't exist. You have to remember that solicitor-client privilege only attaches to communications and documents that were made for the purpose of confidential legal advice. So you can't throw a magic cloak over everything. Not only that, but it's not in the interest of the administration of justice to throw the cloak over everything, because then you end up with boxes and boxes and boxes of stuff sitting in QB, and Queen's Bench doesn't want all these boxes of things. The council now has to go and try and review them all, and then a bunch of them go back to a court to have a judge review. This is a very time-consuming process. So please don't try and throw the magic cloak over all the documents. Now, obviously, there are going to be instances in the execution of a search warrant where there are a bunch of documents that counsel or an employee haven't had time to review. They think might be solicitor-client privilege documents in there. They're not sure. It's very prudent to claim privilege over that bunch of documents you're not sure about. That's not the same thing as claiming privilege over all the documents, okay? Just the ones that you think, I think there might be something in here, or I'm not sure, haven't had time to review it. That can be sealed, and then you can go later and look at them in detail, however many days you want to spend in Queen's Bench to go through them. And this actually happens a lot. So route B was claiming privilege over a bunch of previously existing documents that you had the vice principal of the company send to you the day before the search warrant was executed. Are those documents solicitor-client privileged? No. The short answer is no. So pre-existing documents are not privileged just by virtue of being passed to a lawyer. And there's a nice case, Kilbreth, it's a Saskatchewan Queen's Bench case from 2004 that gets into this point. The longer answer is that in that bunch of documents that you had the VP send to you, there may have been truly some solicitor-client privilege documents. But my point is that you can't make documents privileged just by having them passed to you. Okay? I have seen this several times attempted in environmental cases. Route C is the company's internal investigation report. Is it solicitor-client privileged? And the answer is maybe. It depends on the facts. So internal investigation reports, for those of you that aren't familiar with them, they're reports that are done by a company following an incident in order to determine what happened in the incident and to give them some idea of what changes we can make so that incident doesn't happen again. It's generally the primary purpose of an internal investigation report. And often these reports are required by the company. They're actually in the written procedures that the company has, that following an incident, they're required to do a report. But that internal investigation report doesn't become solicitor-client privileged simply by passing the report to a lawyer. So that point that I was making before under point B. Also, an internal investigation report does not become solicitor-client privilege just by writing solicitor-client privilege on it. These are two things that I have seen done on more than one occasion. In order for that internal investigation report to be solicitor-client privileged, it had to be created for a purpose related to seeking and giving legal advice. So it's not enough to have a lawyer say, you guys should go out there and do an internal investigation report. Right? That doesn't make the report solicitor-client privilege, just saying go out and do it. It's a little bit more than that. The lawyer actually needs to be doing something with that internal investigation report with respect to providing legal advice in order to make it solicitor-client privilege, or have the intention of doing something with that report. Depending on where the investigation is, they may have suggested it happen with the intention of doing something with it for legal advice and just not gotten there yet. Okay? In the environmental investigations I have been involved with, I have not actually seen an internal investigation report that was truly solicitor-client privileged. It can definitely happen. I've seen claims of it, but the claims I've seen have not actually come to fruition. More often than not, I see internal investigation reports that are more potentially litigation privileged than solicitor-client privileged. And we'll talk about that next. Route D was documents which are legal advice between a lawyer and the company. Yes, those are obviously solicitor-client privileged if they're legal advice. I need to talk a little bit about work product privilege and litigation privileged. There's sort of two names to opposite sides of the coin. Work product privilege is very common in environmental enforcement, and it attaches to the Crown. So work product privilege is the work product of Crown Counsel in preparing for criminal or regulatory proceedings. Litigation privilege is similar, and I'll talk about that in a minute. But work product privilege for Crown Counsel can include things like notes of phone conversations, memorandums, briefing notes, discussions. There is a caveat in that when Crown Counsel is preparing for trial, if they find out any evidence that is new, for instance, sometimes I'll be preparing a witness for trial and all of a sudden something completely new will come out of their mouth that no one's ever heard of before during the investigation. That information has to be disclosed. It might be part of my work product, but it's new information that I have an obligation to disclose to the accused. Okay. So work product privilege is a little bit narrower than litigation privilege because of that disclosure obligation to the accused. Litigation privilege is the same idea as work product privilege, but it's in the civil realm. Litigation privilege attaches to documents and communications that were prepared or gathered by counsel themselves or someone under counsel's direction for the purpose of anticipated litigation. And it has to be reasonably anticipated litigation. You'll find out why in a few minutes. You'll see I have 3 bullets of things that I'd like to touch on very briefly. One is settlement negotiations. So communications and documents regarding settlement negotiations fall under work product and litigation privilege. The other point is on expert reports. I was expecting there to be more discussion yesterday with respect to the expert information that was provided with respect to the Ontario Court of Appeal decision that came out at the end of January on Moore versus Getahun. I'm not going to get into a lot of detail with it, but I would like to summarize it very briefly. Basically, the court said that unless there are facts to reasonably suspect that counsel interfered with the objectivity or independence of an expert witness, the communications between the lawyer and the expert witness and the draft reports don't need to be disclosed. That's sort of in a nutshell. But I often wonder, in my world, in environmental prosecutions, do the cases dealing with experts in the civil realm apply? Because I have a very stringent disclosure obligation to the accused. Do my communications with experts and do draft reports need to be disclosed? I don't have an answer to that question. I have never seen any case law on point. But I would argue that whatever the flavor of the day is for civil cases, and I think the flavor of the day right now is Moore versus Getahun, that the criminal process should follow the same thing. And because the reasons are similar, and in environmental enforcement, the experts I'm dealing with are scientists on very technical matters who have absolutely no clue about the law. And so I do need to work with them to make them understand the process and the law, to make sure to review their draft reports, make sure the reports can be understood by a layperson, to make sure that they'll be helpful when they're provided to court to the judge. Just to generally make sure their opinion is clear. And I do review drafts and make comments and say, I have no idea what that means, and ask them to rephrase it. I'm not altering their objectivity or their independence, but I do review things. And I would be uncomfortable of having all that information disclosed to the accused because I don't think it's relevant. Internal investigation reports. Actually, I'm going to back up for a second. When I'm talking about expert reports, there's something else that should be mentioned, and that's that there are expert reports created by a company after an incident. So often expert reports will be generated at the company's request after an incident that's happened that they're being investigated for. And when can those expert reports be litigation privileged? There are often things that an investigator during an investigation would like to seize, and sometimes they can be litigation privileged. So if the expert report has been obtained by the company for the purposes of improving their practices, then that report is not litigation privileged and the investigator can get a hold of it. But if that expert report after an incident was created with the purpose of reasonably anticipated criminal or civil proceedings, then litigation privilege applies and it won't be disclosed during an investigation. And I'd like to get into that in a little bit more detail at the end of my presentation here on internal investigation reports. I keep coming back to them because there's something that occur a lot in environmental enforcement. They come up a lot. So as I mentioned before, internal investigation reports are done by a company after an incident to figure out what happened and where we make changes. So that internal investigation report, just like an expert report, can only have litigation privilege attached to it if it was created in part, at least, for the purpose of legal advice and confidential legal advice. I've had defense counsel claim litigation privilege over internal investigation reports that have been seized by search warrant during an investigation. And I've had defense counsel claim that that internal investigation report was litigation privilege because it was created in contemplation of a criminal charge or a civil proceeding. Often, that's not true. Often what it is it's an attempt, a retroactive attempt to have litigation privilege applied to that internal investigation report. That's not always the case, but often it is. Internal investigation reports, case law, there's some interesting case law. I've put Bruce Power and CN Rail up there. These are cases that make it clear that there has to be some sort of evidence, concrete evidence, in order to claim litigation privilege over an internal investigation report, that it was created with a reasonable anticipation of litigation. So that evidence might be notes from a counsel saying, you guys need to do this report because I'm pretty sure that you could be sued over this. And the court's going to look at what was in the minds of the people at the time the report was being done. Were they thinking of potential litigation? Okay. Was it reasonably anticipated? Was the fact that they were thinking about it, was it actually reasonable that they were thinking about this anticipated litigation? So the courts are actually going to scrutinize that. And like I said, the two examples are Bruce Power and CN Rail. But there's an interesting case, Bedinsky, out of the Manitoba Queen's Bench. I would love to use it in a case if it came up. I don't know if I would be successful or not. But it's a little bit contrary, because in that particular case, witness statements were taken for the purpose of anticipated civil litigation. And what the court said was that investigators for the criminal investigation could actually have copies of those witness statements, because those witness statements were not taken for the purpose of the anticipated criminal investigation. They were only taken for the purpose of the anticipated civil suit. And that they're two completely different proceedings, or so the judge said, and as a result, under the criminal investigation, they were not litigation privileged, these witness statements. So it's an interesting decision. I think it's problematic in a few ways, but in some instances it may apply for people. Okay. That's all I have. I don't know if there's time for questions or not.
A couple of minutes for questions? Yes. Thank you. Good. Oh, another one here. Great. Okay. Again, if you can just read the questions,
Sure.
please.
Well, that's long. How do investigators decide a document is solicitor-client privileged? Is it only things labeled solicitor-client privileged? Do they actually consider whether individual documents are privileged? What about documents on hard drives? It's a good question. I actually have an investigator sitting over there. I'd like to ask him, but I kind of know what he'll say. It's not just things that are labeled solicitor-client privileged. They'll look at whether or not the letter is from council. I mean, council always put their letterhead on it. They always have their name, council, senior council. So they look at whether or not if it has a council's name on it, they're going to put it in an envelope. They're not going to read it. They see council's name, it's going to go in an envelope. They're going to presume council's name is on it, it's solicitor-client privileged. And that's one of the reasons why when you'll have at Queen's Bench someone looking at these documents, some of them may or may not be solicitor-client privileged. So the investigators very much err on the side of caution, and anything that looks like it could be goes in a document. Anything that someone tells them could be, it goes in the envelope. The documents all go in. On hard drives, if they're searching hard drives on site and they see anything that might be, if they see anything that's clearly privileged, they'll just skip by. They'll just ignore it. They won't print it out on site, okay? Because often investigators will search hard drives on site and print documents off on site. If they see something that's clearly solicitor-client privileged, they won't even print it out. They just keep going. If they're not certain, they'll print it out, put it in an envelope. Okay. Clients, especially U.S. clients, are quick to generate root cause reports which are circulated to a broad group that may include in-house counsel. How does broad circulation impact claims of privilege? It depends on the type of privilege you're talking about. If you're talking about solicitor-client privilege, if you have broad circulation of a report, you've lost your solicitor-client privilege as soon as you've disclosed it to third parties that aren't connected. With respect to litigation privilege, you haven't lost any privilege if you have a root cause report, which is like an internal investigation report, and you start handing it around to other people. That doesn't mean you've lost litigation privilege at all, because it can still be for the purposes of providing legal advice. That's the key thing. There's one more question. On the issue of whether Moore versus Getahoon civil principles on disclosing expert communications apply to Crown's disclosure obligations. I understand reluctance to disclose prosecutor expert communications, but what about the expert's file, which is more easily disclosed in a civil context? I definitely agree that the expert's file needs to be disclosed in a criminal or regulatory investigation. They need to have all the information that underpins the expert's opinion.
One final question then.
Thank you. Are search warrants executed at the lawyer's office? What happens then? I didn't get into this because that's a whole other bag of worms, kettle of fish, whatever you want to call it. There is a case, R versus Lavallee, which deals with the execution of search warrants in lawyers' offices. It actually doesn't happen very often. I've never had it happen in an environmental context. And there are very specific guidelines under Lavallee, and there's a Supreme Court of Canada case following it that's name I can't remember off the top of my head. And they give out very strict guidelines for dealing with solicitor-client privilege and dealing with lawyers' offices searches.
McCarthy Tetreault versus Ontario in 1993, I think it was, that they did a search warrant in the office and it was upheld.
Yes.
But that's a good case on internal investigation reports because that one, the court upheld the solicitor-client privilege on that.
On that one.
That's
Yeah.
a good case.
Yeah, and I'd forgotten about that one. Thank you. Is that it?
Okay. Well, thank you very much, Erin, I think, for a very useful discussion of privilege.
And on that note, it is my distinct privilege to introduce our next speakers. Josephine Yam is the Executive Director of the Environmental Law Center in Edmonton, and Brenda Heelan-Powell is Staff Counsel. And they're going to be talking about taking judicial notice of climate change in court decisions.
A very pleasant good afternoon. I'm Josephine Yam. I'm Executive Director with the Environmental Law Center. And the Environmental Law Center is a public interest environmental law organization that pursues public research, education, and stakeholder consultation and advice, because at the Environmental Law Center, we believe that law is one of the most powerful tools in ensuring an environmentally sound resources for all of Alberta. And with my colleague over there, Adam, I'd also like to say that Brenda Heelan Powell was supposed to be here, but she was unable to make it. And today we are going to talk about judicial notice of climate change. My presentation is comprised of 4 sections. The first will talk about the science of climate change. And then we will talk about the concept of judicial notice, like Judicial Notice 101 in Canadian jurisprudence. And then we'll talk about judicial notice of climate change in the US, in Canada, and internationally. And then we talk about looking ahead in terms of where is judicial notice of climate change going towards. So the first section, the science of climate change. In June 2013, Calgary experienced catastrophic flooding, and this flood was considered the costliest disaster in Canadian history. There were 4 deaths, there were more than 100,000 people that were rendered homeless, and it created $6 billion in losses. And in terms of insured losses, it cost $1.7 billion. 6 months later, Typhoon Haiyan in the Philippines, my home country, also was ravaged by severe typhoon. It was the strongest typhoon to hit land ever recorded. Unfortunately, it was like a lethal monster. There were 10,000 deaths. There were 11 million people who were left homeless, and more than $2.86 billion in damages. Like the Alberta floods and Typhoon Haiyan in the Philippines, many scientists have attributed increasing greenhouse gas emissions that have caused climate change. But what is the public opinion about climate change? Very interestingly, a polling firm in Toronto about 7 or 8 months ago polled about 1,600 Canadians, and the results were that about 81% believe that the climate is changing, while 13% deny that it is. And the profile of the climate deniers in Canada are Gen X, those 45 to 54 at 18%, males at 17%, mid-income groups at 18%, Atlantic Canada at 19%, Alberta at 20%, conservative voters at 29%, the least educated at 17%, and evangelical Christians at 32%. And as a side note, it's interesting to note that when you look at Canada, actually, those that are not here, like British Columbia, Ontario, and Quebec, are the ones that have actually a carbon pricing policy. So for example, you'll have Quebec that has a cap and trade scheme that's already linked with California under the Western Climate Initiative. You have British Columbia that has had a carbon tax since 2008, and actually has become the poster child for one of the best carbon tax jurisdictions in the world, according to the OECD and the World Bank. And Ontario this spring is actually going to come up with a carbon tax or a cap and trade scheme. So you can see that it's actually influenced by the electorate as well, in terms of where the climate deniers are and where they're not. So that's the arena of public opinion. How about the arena of politics? Many of you probably saw this. It was all over the papers, Washington Post, New York Times, and this was about the US Senate Senator Jim Inhofe's snowball that says, because of his snowball, he has disproven that climate change does not exist once and for all. And this, my colleagues, is the head of climate policy in the US right now. And US Senator Inhofe is the chair of the Environmental and Public Works Committee. He's the author of the book that argues that climate change is the greatest hoax ever perpetrated on the American people. He said, "We keep hearing that 2014 has been the warmest year on record. Well, let me prove you wrong. Here's a snowball." He got it from a plastic bag, and he hurled it at an unsuspecting Senate colleague, which really freaked out everybody. But what's interesting was that the statement that 2014 was the warmest year on record was actually stated by the US government, NASA, the National Aeronautics Space Administration. So for a senator to actually say that NASA was wrong is really very interesting. And so, of course, you can imagine that he became the butt of all jokes in late night shows and Twitter and all that, but that's a different phenomenon altogether. So that's at the Washington Post. Now you wonder, okay, so where does Senator Jim Inhofe and the rest of the climate deniers get their evidence? Again, 2 weeks ago, you probably saw this. The New York Times featured Willie Soon, who's a scientist at Harvard-Smithsonian Center for Astrophysics in Boston. And his claim is that it is not GHGs that are caused by humans that cause climate change, but the variation in the sun's energy that causes climate change. And he appears on Fox News, he testifies before Congress, he's the keynote speaker in all climate denier conferences. Now, through the Freedom of Information Act, what happened was the New York Times reported that documents reveal that he was actually paid $1.2 million by fossil fuel companies. And it was a very unethical situation because when he released his research papers, there was no disclosure whatsoever about that conflict of interest that existed. So the New York Times reported that it seemed like this climate change campaign is like denying climate change is like a campaign of the tobacco industry in the 1960s, where industry will do what it can to cast scientific doubt, to undermine the scientific consensus on climate change. So you ask, what is the scientific consensus on climate change? Well, it's found in the reports given by this international body called the Intergovernmental Panel on Climate Change. In 1988, this body was established by the World Meteorological Organization and the United Nations Environment Program to provide policymakers with regular assessments of scientific basis of climate change. Now, the reports are written by hundreds of leading scientists and reviewed by thousands of experts so that they're comprehensive, objective, and transparent. And they provide rigorous and balanced scientific information to decision makers. So the report covers scientific, technical, and social economic assessment of climate change. What are the conclusions that we get out of these reports? The IPCC's conclusions are, 1, the warming of the climate is undeniably happening. 2, human-caused greenhouse gas emissions are likely causing the warming. 3, adverse climate-related impacts presently occurring and are expected to increase in the future unless there are significant reductions in GHGs that are achieved. And in the 2014 report of the IPCC, it reiterates again that it is extremely likely that human activity is causing climate change. Having spoken about the science of climate change in the various arenas of public opinion and in politics, we now talk about the concept of judicial notice, and very briefly, just to refresh our memories, what is judicial notice? And in the fine case, Chief Justice McLaughlin said, judicial notice dispenses with the need for proof of facts that are clearly uncontroversial or beyond reasonable dispute. The threshold for judicial notice is strict. A court may properly take judicial notice of facts that are either 1, so notorious or generally accepted as not to be the subject of debate among reasonable persons, or 2, capable of immediate and accurate demonstration by resort to readily accessible sources of indisputable accuracy. So why is the judicial notice test strictly applied? Because first, it ensures the efficiency of court processes. It saves time and costs of complying with the formal procedures of submitting evidence. So whenever a fact is judicially noticed, it is not subject to the ordinary processes for testing evidence, like for oaths or cross-examination. And that's why a balance has to be struck, because there are really concerns about fairness and accuracy, especially in common law presidential systems. So in the Spence case, in respect of the approach to judicial notice, the Supreme Court established a principled approach in determining whether or not to take judicial notice of a fact. And it is whether a fact is adjudicative or not adjudicative, and how close the fact is to the dispositive issue. So Justice Binnie used the informed reasonable person test, and he said, I believe a court ought to ask itself whether such fact would be accepted by reasonable people who have taken the trouble to inform themselves on the topic as not being the subject of reasonable dispute for the particular purpose for which it is used, keeping in mind that the need for reliability and trustworthiness increases directly with the centrality of the fact to the disposition of the controversy. Having talked about the concept of judicial notice, we now move to the third section, which is judicial notice of climate change. So we've seen more or less what climate change looks like in the public opinion arena. Then we've seen what it looks like in the political arena. So now we looked at it, what is the stand of climate change in the judiciary? Although there are still debates on the existence or cause of global warming, those debates are not taking place in the courts. As climate change science has developed, courts have actually taken judicial notice of it. So we will see it in the US setting, in the Canadian setting, and an example in the international setting. In the US, courts have heavily relied on the IPCC reports. Why? Because the IPCC reports have various indicias of reliability favored by the US laws of evidence. They're easy to read, they're peer-reviewed, there's a very strong consensus on climate change. It's backed by highly credentialed organizations and scientists, and because the scientific analysis has been developed outside of litigation, courts have given a lot of credit to the conclusions. As one commentary in the American Bar Association said, the IPCC reports are dream evidence for a litigator. In fact, no judge except in one dissent has expressed skepticism about the science underlying climate change. And so we have, and we're going to deal with it in the next slide, the landmark case of Massachusetts versus the Environmental Protection Agency, which gave a very express and deliberate recognition of climate science. So now the debates in the courts are not whether climate change exists or what the cause is, which is it's anthropogenic or it's human caused, but the debate is more around what its impacts are and who becomes liable for it. So in the US Supreme Court case in Massachusetts versus EPA in 2007, this was a case involving greenhouse gas emissions as constituting quote-unquote air pollutants under the Clean Air Act. And the Supreme Court rejected the EPA's reasons for refusing to make an endangerment finding under the Clean Air Act. And how did the court here take judicial notice? And it said, a well-documented rise in global temperatures has coincided with a significant increase in the concentration of carbon dioxide in the atmosphere. Respected scientists believe the two trends are related. The Supreme Court also said, the harms associated with climate change are serious and well recognized. It also said, the EPA does not dispute the existence of a causal connection between man-made greenhouse gas emissions and global warming. And it said, the rise in sea levels associated with global warming has already harmed and will continue to harm Massachusetts. The risk of catastrophic harm, though remote, is nevertheless real. And this was monumental because this was the first time that the US Supreme Court actually took judicial notice of climate change. And this then was like a tidal wave and created a lot of ripple throughout the US and other state courts as well. The second case I'd like to talk about in the US experience is Green Mountain versus Crombie in 2007. This is a case involving the auto industry challenging the state of Vermont's adoption of California's greenhouse gas emission standards for new automobiles. And this case was considered a significant victory in courts for the consensus on the scientific position on global warming. This was also hailed as a major victory for states' efforts to combat climate change. And here the court said that global warming is taking place as a result of human emissions of carbon dioxide and other greenhouse gases, and that its consequences are likely to be harmful, is widely accepted in the scientific community. Quoting the Supreme Court in Massachusetts, the court in this case said that the harms associated with climate change are serious and well recognized. In a third case I'd like to discuss is the Wall versus City of New York in 2011. And in this case, it involved New York homeowners alleging negligence on the part of the City of New York because of the floods that damaged their residences and cars in August of 2011. And the court ruled that the New York City was not negligent. Why? Because the court took judicial notice of the climatological reports from the National Climatic Center and found that the reports prove that New York City had been, and I quote, subjected to inordinate rainfall during 2 storms in August 2011, one of which was Hurricane Irene. And the New York City also provided uncontroverted evidence that showed that the sewer system they had was never really designed to accommodate such volume of rain. And if many of us have recalled, that was like, it put New York City really on hold, and was like Wall Street was closed for about a week and a half because of this flood. And 56 people died, unfortunately, in this instance. And in this case, the court held that New York City met its burden of demonstrating that the sole proximate cause of flooding that occurred was the volume of precipitation rather than the inspection and maintenance failures that what the homeowners were trying to attribute to New York City. And a very recent case that just happened last year actually is Commonwealth versus Ward in the state of Massachusetts. And here in 2013, 2 climate activists used a lobster boat to block a coal shipment that was going into Somerset, Massachusetts. So they were charged with criminal conspiracy, and their defense was, they were using the necessity defense under common law in the US, saying that climate change is a clear and imminent danger, and our actions to block this coal shipment is an action that would eliminate or mitigate that danger, and therefore, because there's no legal alternative to mitigate or eliminate this danger, we are going to block this coal shipment. And what did the court hold in this case? Interestingly, the district attorney of Massachusetts sort of agreed. And he said that, indeed, climate change is one of the gravest crises on our planet has ever faced. And he did say very courageously, which I'm very surprised, he said, in my humble opinion, the political leadership on this issue has been sorely lacking. And so he ended up charging the 2 climate activists with just public nuisance. Having talked about what the US experience is on the judicial notice of climate change, we now move to the Canadian experience. And there's just one significant case, which is Syncrude versus Canada in 2014, and which was comprehensively blogged by U of C law professors here. And in this case, Syncrude challenged the validity of the federal renewable fuels regulation on constitutional and administrative grounds. Syncrude said, production and consumption of petroleum fuel is not dangerous and does not pose a risk to human health or safety. And they said, there is no evil to be suppressed here. However, the court disagreed. And Justice Zinn said, and I quote, the evil of global climate change and the apprehension of harm resulting from the enabling of climate change through combustion of fossil fuels has been widely discussed and debated by leaders on the international stage. And contrary to Syncrude's submission, this is a real, measured evil, and the harm has been well documented. It was a very strong statement from the courts taking judicial notice of climate change against a very powerful oil and gas company. And one case I'd like to highlight in the international sphere is a case against the New Zealand Immigration Board. And this happened also last year. What happened was there was a Tuvalu family that applied for New Zealand residency, but they were denied, and that's why they were appealing the case. The family argued that they were at risk of suffering the adverse impacts of climate change if they were deported back to Tuvalu. Tuvalu is a very small island of about 11,000 people. It's an island in the Pacific between Hawaii and Australia, and it's considered as a canary in a coal mine. It's going to be one of the first nations to experience the effects of sea level rise caused by climate change. Interestingly, the tribunal in the case acknowledged that climate change impacts may affect the enjoyment of human rights, but it explicitly declined to reach the question of whether climate change provided a basis for granting resident visas. So what happened here was the tribunal actually granted this family New Zealand resident visas on the ground of exceptional circumstances of a humanitarian nature, by saying that the kids were already very accustomed to New Zealand life, and they had extended family, and they belonged to a community. But the court here refused to make any finding about, yes, climate change is a very strong reason to keep them here and give them visas, because that would then incite a whole slew of millions of people as climate change refugees going to New Zealand. Having talked about the science of climate change in the public opinion arena, and the political arena, and in the judicial arena, what now? How does it look like going forward? Climate change litigation is actually very strong in a litigious society like the US. There's 420 cases thus far, and it actually dwarfs all the other non-US litigation cases in the leading 5 jurisdictions of Australia, New Zealand, the EU, Spain, and the United Kingdom. Interestingly also, there's sort of like a profile of the type of US litigation cases that are going and are being foisted. And the cases are used as a strategy to spur and halt climate regulations. Also, litigation is used to shape the development of climate regulations. Juxtapose this against those in the non-US, like in Europe, for example. The strategy of using litigation is aimed at the implementation of existing climate policy. So they're not here anymore to stop the formation of climate policy. They just are litigating how they're being implemented, especially in the EU emissions trading system, where since 2007 there was a cap and trade scheme among 31 countries, and now the question's always regarding the implementation of specific policies and regulations. First, one of the conclusions from the judicial notice of climate change is there is no consistent fact pattern for climate change litigation. The major litigation categories are so varied because they reflect each jurisdiction's unique legislative, regulatory framework, energy portfolios, and legal systems. Also, it's been recognized that climate change is treated in courts like an ordinary environmental issue. It doesn't result in development of distinct climate change jurisprudence, and the future of substantive climate change litigation is less certain depending on the political will of the government to implement and enforce climate change legislation. Climate change litigation in Canada, as you can see, still it's in infancy, and there's really a plethora of opportunities to explore the extent of liability in public and private law. And as mentioned earlier, the success of any climate litigation will turn on the factual basis that is established by counsel. And interestingly, despite scientific agreement that greenhouse gas emissions cause climate change, it's difficult to prove contribution of specific defendants to the problem in a specific location. So now we're seeing that climate change litigation is actually being used for 3 purposes. One, it's to keep the pressure on fossil fuel companies and other large emitters. 2, it is to keep the issue in the public mind because media coverage is inadequate or sometimes even misleading. And 3, litigation is considered as a great tactic to send a message to the legislature that comprehensive legislation is needed. And current statutes are just not sufficient because many statutes have never really contemplated climate change. On that note, thank you very much and have a pleasant good afternoon.
can we take some questions? If anyone has any questions, if you could write them on the card or send them in over the internet. Let me start with one question. Justice Binney, in his decision, talked about the closer an issue gets to the centrality of the case in issue, the less likely it is to get judicial notice. Do you think that might explain some of the cases on judicial notice of climate change?
You know, interestingly, one of the comments about the profile of climate change litigation, it hasn't really been central to a substantive issue. It has more been a procedural issue, or, for example, like in respect of environmental impact assessments, suing the administrative or regulatory agency that they didn't do an environmental impact assessment. So climate change in itself really hasn't been the central issue, and so whether it was adjudicative or not wasn't really something that was pursued vigorously in this climate change litigation vis-a-vis what Justice Binney said.
And I would think sort of consistent with that is, as a litigation lawyer, you need to pick your spots and pick your battles, and maybe that's one of the reasons nobody wants to take that on, because if you can decide a case on another issue, it's much easier.
Yes.
Are there any questions from the audience? Okay, well, thank you very much. Appreciate it. And last, but certainly not least, Sarah Powell is going to give a presentation on regional approaches and different things going on around the country.
Okay, you do it, and when we talk about next year's, I'll get that up.
So Josephine did a fabulous job at keeping us on time or ahead of time, and I'm going to do even better. And has nothing to do with a plane that I have to catch. So what we do generally, traditionally, at the end of the Canadian Bar Association is we have a discussion about what are some of the topics coast to coast to coast in environmental law, and what are we thinking about in the year to come. And so because we had such an intensive Friday, what we decided to do today was really not do that panel on case law update, because we thought we covered the bulk of it in a series of speakers. But what I wanted to say are just two things that NERLS is really focusing on as we go forward, just to give you the heads up. The first is climate, and Josephine set the stage for that. This year and next are very important years, and I say that every year, those of you who know me. This is going to be a big year for climate. So I'm still crossing my fingers. But the end of this month, March 31st, Canada is to submit its commitment, or contribution as they're called now, with respect to climate. And I thought it was interesting because it's been a pretty quiet process for those who aren't intimately involved in it, because it's a pretty significant decision. And the federal government has been reaching out to the provinces, but I thought in the last week there's been some press coverage on it if you follow it, and so I thought I'd just give you the heads up on that because it's interesting. So the spokesperson for the Minister of Environment federally, by way of email, because she wasn't available for an interview, which is shocking. She said that she wanted to communicate that the federal government is actively preparing its intended nationally determined contribution. So that's the contribution that's due on March 31st. As this is a national contribution, the provinces and territories hold many levers for taking action on emissions. So the minister is seeking feedback from her counterparts. So keep in mind we have our Copenhagen commitment, which is to 2020. And so what's being discussed now and what we're talking about is the post-2020. So yesterday, I don't know if you saw it in the news, but the Premier of BC was in Ottawa, and she was responding to this counterpart question, and she said, nobody benefits in Canada from a fiddling interventionist federal government that wants to start telling provinces how to manage the economy and the environment. So there was the tone yesterday, but she was sharing the stage with the Premier, Alberta Premier Prentice, and he said, after she said the fiddling interventionist federal government comment, He said that Alberta has been the victim of unfair perceptions with respect to our environmental standards and performance. And he reiterated that Alberta would not act to adopt tougher rules until the U.S. adopts GHG regs for its own oil sector. So even as we're sitting at this 11:59 before we're supposed to be filing our contribution commitment, you can see that there's not a huge meeting of the minds of how that's going to come about. Alberta has extended its regulations and regulatory framework on GHGs until June 2015, I think it is. So when I say it's going to be a big year, I do think it's going to be a big year because I do think Alberta is going to be the leader on setting where Canada is going to go, because much of this is going to be driven by subnationals and not by the federal government. Also, all of the premiers are meeting in April in Quebec, and they're meeting again in June in Toronto with other subnational governments to see whether California and a whole bunch of New England states. So I tell you all of this because NERLS will be organizing either pre-COP21 or just post-COP21. We had talked about it on Thursday and agreed that it made sense, a webinar to follow up on what's happening not only in Alberta but coast to coast on this. So stay tuned for that, but that's certainly, I think, a very important thing for all of us in the room to monitor and to find out what the ultimate result is. Also, we wanted to give a heads up, and I think really Scott Smith talked about this, about the confluence of Aboriginal environmental law. On that issue, NERLS has been very active with the Aboriginal section. We spoke in Iqaluit in 2014. We also co-organized with Aboriginal Affairs in St. John's a very interesting roundtable that I wish we had have done by way of webinar because it was the funniest roundtable ever. And so we're thinking that is the confluence of Aboriginal law and what's happening in particularly north of 60. We have had roundtables on that before in 2013 in Yellowknife, but we think there's a big interest on what's happening in many of the territories, in particular Northwest Territories, on devolution. And I just point out one case that's interesting on the devolution that you may have seen on February 27th of this year. The Northwest Territorial Supreme Court granted the Tliko government an injunction to delay the elimination of the Wukasi Water Board. And you may remember that under the federal statute, all of the local water boards were being eliminated and rolled into one kind of super water board, and so a land and water board. So that's very interesting. The main case in that matter will be, I think, argued sometime in 2015. So that's something to keep in mind, because I think the devolution is so important for us to understand, not just in Northwest Territories, but also in Nunavut. So we did talk about on Thursday at our pre-executive meeting about having a webinar sometime in 2016 probably on talking about those issues about devolution north of 60 and the confluence of Aboriginal and environmental energy and resource law. So if you have any interest in climate, or if you have any interest in that confluence or what's happening north of 60, we invite you to let Stuart know. And if you want to participate in the organization or find out more information, just to reach out, because more heads are better than one on all of this. And finally, before I go to my official thanks, I did just want to say that the Canadian Bar Association has an approval process for our law summit, and that process will be starting in the spring of 2015 for 2016. So there's a bureaucratic process we have to go through to figure out what to do in 2016. But at this point, the executive is looking at St. John's in Newfoundland in June 2016. So if you want to put it in your calendar and are interested, again, that will likely be on a resource focus, not so focused on environmental litigation, but we'll keep you posted. And if you need an excuse to go to St. John's, and nobody needs an excuse to go to St. John's, we will do our best to make it as entertaining as the last one we had there in August 2014. So I am then just going to close out and pass over to Alan, who's going to talk about what they're thinking about next for their next session. And before I do that, though, there's a huge amount of thanks. Thank you to Environment Canada, notwithstanding what I just said about the minister. Thank you, I mean that with all respect, since this is being taped. Also to the University of Calgary, to Alan and all of his folks, to Sue and to Nancy, who have just been awesome in making this all work. It looks so seamless, but there's just a massive effort behind the scenes, and we are so super grateful to be in such a fabulous place. So quick hand. Thank you, thank you. Thank you, Nancy. On our side, also thank you to Tina for doing a fabulous job as always. She is our secret weapon in making all of this work. And thank you to all the speakers. It just would not happen without your help, and so we're very, very grateful for the quality and for the papers, which we know everybody's super busy, so we're very grateful for that as well. And finally, I just wanted to do very housekeeping issues. You will get a survey. Please, please, please fill it out. Again, this has been free, so just give us 2 minutes of your time, because we need your feedback to make the next sessions better. Any papers that haven't been posted or presentations will be posted over the short term, so just keep an eye out. We want to recycle your badges, so give them back to Tina. And I think that that's everything. I'm looking at Stuart to see if I've missed anything on the CBA end.
Other than we're an hour earlier than the taxis we ordered, everything's good.
Yeah. Well, maybe she can reorder. You can all talk for a little bit. Plus, no, we're not all done yet, though. Alan's going. We've got lots more to talk about. So thank you for that. And I want to thank our sponsors. So Environ has been great as our lead sponsor and has been a really good friend to CBA. So thank you to Environ. And all the other sponsors who gave of their time and money, we're very grateful. So now I'm going to turn it over to Alan. Thank you again. Have a safe trip home. Thanks for your donations to the Alex. We came in just around $300, and we're going to top that up to about $500. So that's great, just as a small thanks. And I'm now going to turn it over to Alan.
Thank you, Sarah. So I thought I would conclude by outlining the theme of next year's symposium. And again, I'd like to thank, in particular, Environment Canada for their ongoing support of the symposium over the past 4 years. So next year's symposium will focus on federal and provincial preventative, remedial, and punitive powers in the context of inspections and enforcement issues, both on-site and in the court. Some of the proposed sessions, and these are things that we'd outlined in our initial proposal, will include an overview of the powers and orders in environmental legislation, the role of inspectors, substantive and procedural rights in the face of inspections, basically what to do when the inspector shows up, self-reporting requirements and their legal implications, charter issues, different tests for different orders, for example, reasonable belief versus probable grounds. If you have any suggestions for topics or issues that you'd like covered, please email me in the interim. And the final thanks, which we haven't made, of course, is to you as the audience. Without your insightful questions and comments, it would not be the success that it's been. So thank you very kindly for participating, and we look forward, hopefully next year, to your contributions. So have a great afternoon.